Tripartite Declaration of Principles Concerning Multinational Enterprises and Social Policy, adopted at Geneva on 16 November 1977. The governing body of the International Labour Office, recalling that the International Labour Organization for many years has been involved with certain social issues related to the activities of multinational enterprises, noting in particular that various industrial committees, regional conferences, and the International Labour Conference since the mid-1960s have requested appropriate action by the governing body in the field of multinational enterprises and social policy. Having been informed of the activities of other international bodies, in particular the UN Commission on Transnational Corporations and the Organization for Economic Cooperation and Development, OECD, considering that the ILO, with its unique tripartite structure, its competence, and its long-standing experience in the social field, has an essential role to play in evolving principles for the guidance of governments, workers and employers organizations, and multinational enterprises themselves, recalling that it convened a tripartite meeting of experts on the relationship between multinational enterprises and social policy in 1972, which recommended an ILO program of research and study, and a tripartite advisory meeting on the relationship of multinational enterprises and social policy in 1976 for the purpose of reviewing the ILO program of research and suggesting appropriate ILO action in the social and labor field, bearing in mind the deliberations of the World Employment Conference. Having thereafter decided to establish a tripartite group to prepare a draft tripartite declaration of principles covering all of the areas of ILO concern which relate to the social aspects of the activities of multinational enterprises, including employment creation in the developing countries, all the while bearing in mind the recommendations made by the Tripartite Advisory Meeting held in 1976. Having also decided to reconvene the Tripartite Advisory Meeting to consider the draft Declaration of Principles as prepared by the Tripartite Group. Having considered the report and the draft Declaration of Principles submitted to it by the reconvened Tripartite Advisory Meeting, hereby approves the following declaration, which may be cited as the Tripartite Declaration of Principles Concerning Multinational Enterprises and Social Policy, adopted by the governing body of the International Labour Office, and invites governments of states members of the ILO, the employers and workers organizations concerned and the multinational enterprises operating in their territories to observe the principles embodied therein. 1. Multinational enterprises play an important part in the economies of most countries and in international economic relations. This is of increasing interest to governments as well as to employers and workers and their respective organizations. Through international direct investment and other means, such enterprises can bring substantial benefits to home and host countries by contributing to the more efficient utilization of capital, technology and labor. Within the framework of development policies established by governments, they can also make an important contribution to the promotion of economic and social welfare, to the improvement of living standards and the satisfaction of basic needs, to the creation of employment opportunities, both directly and indirectly, and to the enjoyment of basic human rights, including freedom of association, throughout the world. On the other hand, the advances made by multinational enterprises in organizing their operations beyond the national framework may lead to abuse of concentrations of economic power and to conflicts with national policy objectives and with the interest of the workers. In addition, the complexity of multinational enterprises and the difficulty of clearly perceiving their diverse structures, operations and policies sometimes give rise to concern either in the home or in the host countries, or in both. 2. The aim of this Tripartite Declaration of Principles is to encourage the positive contribution which multinational enterprises can make to economic and social progress and to minimize and resolve the difficulties to which their various operations may give rise, taking into account the United Nations resolutions advocating the establishment of a new international economic order, as well as subsequent developments within the United Nations. For example, the Global Compact and the Millennium Development Goals. 3. This aim will be furthered by appropriate laws and policies, measures and actions adopted by the governments and by cooperation among the governments and the employers and workers' organizations of all countries. 4. The principles set out in this declaration are commended to the governments, the employers and workers' organizations of home and host countries, and to the multinational enterprises themselves. 5. These principles are intended to guide the governments, the employers and workers' organizations and the multinational enterprises in taking such measures and actions and adopting such social policies, including those based on the principles laid down in the Constitution and the relevant conventions and recommendations of the ILO, as would further social progress. 6. To serve its purpose, this declaration does not require a precise legal definition of multinational enterprises. This paragraph is designed to facilitate the understanding of the declaration and not to provide such a definition. Multinational enterprises include enterprises, whether they are of public, mixed or private ownership, which own or control production, distribution, services or other facilities outside the country in which they are based. The degree of autonomy of entities within multinational enterprises in relation to each other varies widely from one such enterprise to another, depending on the nature of the links between such entities and their fields of activity, and having regard to the great diversity in the form of ownership, in the size, in the nature and location of the operations of the enterprises concerned. Unless otherwise specified, the term multinational enterprise is used in this declaration to designate the various entities, parent companies or local entities or both, or the organization as a whole, according to the distribution of responsibilities among them, in the expectation that they will cooperate and provide assistance to one another as necessary to facilitate observance of the principles laid down in the declaration. 7. This declaration sets out principles in the fields of employment, training, conditions of work and life and industrial relations which governments, employers and workers' organizations and multinational enterprises are recommended to observe on a voluntary basis. Its provisions shall not limit or otherwise affect obligations arising out of ratification of any ILO convention. General policies. 8. All the parties concerned by this declaration should respect the sovereign rights of states, obey the national laws and regulations, give due consideration to local practices and respect relevant international standards. They should respect the Universal Declaration of Human Rights and the corresponding international covenants adopted by the General Assembly of the United Nations, as well as the Constitution of the International Labour Organization and its principles, according to which freedom of expression and association are essential to sustained progress. They should contribute to the realization of the ILO Declaration on Fundamental Principles and Rights and Work and its follow-up, adopted in 1998. They should also honor commitments which they have freely entered into, in conformity with the national law and accepted international obligations. 9. Governments of states which have not yet ratified conventions Nos. 29, 87, 98, 100, 105, 111, 122, 138 and 182 are urged to do so, and in any event to apply, to the greatest extent possible, through their national policies, the principles embodied therein and in recommendations Nos. 35, 90, 111, 119, 122, 146, 169, 189 and 190. Without prejudice to the obligation of governments to ensure compliance with conventions they have ratified, in countries in which the conventions and recommendations cited in this paragraph are not complied with, all parties should refer to them for guidance in their social policy. 10. Multinational enterprises should take fully into account established general policy objectives of the countries in which they operate. Their activities should be in harmony with the development priorities and social aims and structure of the country in which they operate. To this effect, consultations should be held between multinational enterprises, the government and, wherever appropriate, the national employers and workers' organizations concerned. 11. The principles laid down in this declaration do not aim at introducing or maintaining inequalities of treatment between multinational and national enterprises. They reflect good practice for all multinational and national enterprises, wherever the principles of this declaration are relevant to both, should be subject to the same expectations in respect of their conduct in general and their social practices in particular. 12. Governments of home countries should promote good social practice in accordance with this declaration of principles, having regard to the social and labor law, regulations and practices in host countries as well as to relevant international standards. Both host and home country governments should be prepared to have consultations with each other, whenever the need arises, on the initiative of either. Employment promotion. 13. With a view to stimulating economic growth and development, raising living standards, meeting manpower requirements and overcoming unemployment and underemployment, governments should declare and pursue, as a major goal, an active policy designed to promote full, productive and freely chosen employment. 14. This is particularly important in the case of host country governments in developing areas of the world where the problems of unemployment and underemployment are at their most serious. In this connection, the general conclusions adopted by the Tripartite World Conference on Employment, Income Distribution and Social Progress and the International Division of Labor, Geneva, June 1976, and the Global Employment Agenda, Geneva, March 2003, should be kept in mind. 15. Paragraphs 13 and 14 above establish the framework within which due attention should be paid, in both home and host countries, to the employment impact of multinational enterprises. 16. Multinational enterprises, particularly when operating in developing countries, should endeavor to increase employment opportunities and standards, taking into account the employment policies and objectives of the governments, as well as security of employment and the long-term development of the enterprise. 17. Before starting operations, multinational enterprises should, wherever appropriate, consult the competent authorities and the national employers and workers' organizations in order to keep their manpower plans, as far as practicable, in harmony with national social development policies. Such consultation, as in the case of national enterprises, should continue between the multinational enterprises and all parties concerned, including the workers' organizations. 18. Multinational enterprises should give priority to the employment, occupational development, promotion and advancement of nationals of the host country at all levels in cooperation, as appropriate, with representatives of the workers employed by them or of the organizations of these workers and governmental authorities. 19. Multinational enterprises, when investing in developing countries, should have regard to the importance of using technologies which generate employment, both directly and indirectly. To the extent permitted by the nature of the process and the conditions prevailing in the economic sector concerned, they should adapt technologies to the needs and characteristics of the host countries. They should also, where possible, take part in the development of appropriate technology in host countries. 20. To promote employment in developing countries, in the context of an expanding world economy, multinational enterprises, wherever practicable, should give consideration to the conclusion of contracts with national enterprises for the manufacture of parts and equipment, to the use of local raw materials and to the progressive promotion of the local processing of raw materials. Such arrangements should not be used by multinational enterprises to avoid the responsibilities embodied in the principles of this declaration. Equality of opportunity and treatment. 21. All governments should pursue policies designed to promote equality of opportunity and treatment in employment, with a view to eliminating any discrimination based on race, color, sex, religion, political opinion, national extraction or social origin. 22. Multinational enterprises should be guided by this general principle throughout their operations without prejudice to the measures envisaged in paragraph 18 or to government policies designed to correct historical patterns of discrimination and thereby to extend equality of opportunity and treatment in employment. Multinational enterprises should accordingly make qualifications, skill and experience the basis for the recruitment, placement, training and advancement of their staff at all levels. 23. Governments should never require or encourage multinational enterprises to discriminate on any of the grounds mentioned in paragraph 21, and continuing guidance from governments, where appropriate, on the avoidance or such discrimination in employment is encouraged. Security of employment. 24. Governments should carefully study the impact of multinational enterprises on employment in different industrial sectors. Governments, as well as multinational enterprises themselves, in all countries should take suitable measures to deal with the employment and labor market impacts of the operations of multinational enterprises. 25. Multinational enterprises equally with national enterprises, through active manpower planning, should endeavor to provide stable employment for their employees and should observe freely negotiated obligations concerning employment stability and social security. In view of the flexibility which multinational enterprises may have, they should strive to assume a leading role in promoting security of employment, particularly in countries where the discontinuation of operations is likely to accentuate long-term unemployment. 26. In considering changes in operations, including those resulting from mergers, takeovers or transfers of production, which would have major employment effects, multinational enterprises should provide reasonable notice of such changes to the appropriate government authorities and representatives of the workers in their employment and their organizations so that the implications may be examined jointly in order to mitigate adverse effects to the greatest possible extent. This is particularly important in the case of the closure of an entity involving collective layoffs or dismissals. 27. Arbitrary dismissal procedures should be avoided. 28. Governments, in cooperation with multinational as well as national enterprises, should provide some form of income protection for workers whose employment has been terminated. Training. 29. Governments, in cooperation with all the parties concerned, should develop national policies for vocational training and guidance, closely linked with employment. 9. This is the framework within which multinational enterprises should pursue their training policies. 30. In their operations, multinational enterprises should ensure that relevant training is provided for all levels of their employees in the host country, as appropriate, to meet the needs of the enterprise as well as the development policies of the country. Such training should, to the extent possible, develop generally useful skills and promote career opportunities. This responsibility should be carried out, where appropriate, in cooperation with the authorities of the country, employers and workers' organizations and the competent local, national or international institutions. 31. Multinational enterprises operating in developing countries should participate, along with national enterprises, in programs, including special funds, encouraged by host governments and supported by employers and workers' organizations. These programs should have the aim of encouraging skill formation and development as well as providing vocational guidance, and should be jointly administered by the parties which support them. Wherever practicable, multinational enterprises should make the services of skilled resource personnel available to help in training programs organized by governments as part of a contribution to national development. 32. Multinational enterprises, with the cooperation of governments and to the extent consistent with the efficient operation of the enterprise, should afford opportunities within the enterprise as a whole to broaden the experience of local management in suitable fields such as industrial relations, conditions of work and life, wages, benefits and conditions of work. 33. Wages, benefits and conditions of work offered by multinational enterprises should be not less favorable to the workers than those offered by comparable employers in the country concerned. 34. When multinational enterprises operate in developing countries, where comparable employers may not exist, they should provide the best possible wages, benefits and conditions of work, within the framework of government policies. These should be related to the economic position of the enterprise, but should be at least adequate to satisfy basic needs of the workers and their families. Where they provide workers with basic amenities such as housing, medical care or food, these amenities should be of a good standard. 35. Governments, especially in developing countries, should endeavor to adopt suitable measures to ensure that lower-income groups and less developed areas benefit as much as possible from the activities of multinational enterprises. Minimum age, 36. Multinational enterprises, as well as national enterprises, should respect the minimum age for admission to employment or work in order to secure the effective abolition of child labor and should take immediate and effective measures within their own competence to secure prohibition and elimination of the worst forms of child labor as a matter of urgency. Safety and health. 37. Governments should ensure that both multinational and national enterprises provide adequate safety and health standards for their employees. Those governments which have not yet ratified the ILO Conventions on Guarding of Machinery, number 119, ionizing radiation, number 115, benzene, number 136, and occupational cancer, number 139, are urged nevertheless to apply to the greatest extent possible the principles embodied in these conventions and in their related recommendations, Nos. 118, 114, 144 and 147. The list of occupational diseases and the codes of practice and guides in the current list of ILO publications on occupational safety and health should also be taken into account. 38. Multinational enterprises should maintain the highest standards of safety and health, in conformity with national requirements, bearing in mind their relevant experience within the enterprise as a whole, including any knowledge of special hazards. They should also make available to the representatives of the workers in the enterprise, and upon request, to the competent authorities and the workers' and employers' organizations in all countries in which they operate, information on the safety and health standards relevant to their local operations, which they observe in other countries. In particular, they should make known to those concerned any special hazards and related protective measures associated with new products and processes. They, like comparable domestic enterprises, should be expected to play a leading role in the examination of causes of industrial safety and health hazards and in the application of resulting improvements within the enterprise as a whole. 39. Multinational enterprises should cooperate in the work of international organizations concerned with the preparation and adoption of international safety and health standards. 40. In accordance with national practice, multinational enterprises should cooperate fully with the competent safety and health authorities, the representatives of the workers and their organizations, and established safety and health organizations. Where appropriate, matters relating to safety and health should be incorporated in agreements with the representatives of the workers and their organizations. Industrial relations. 41. Multinational enterprises should observe standards of industrial relations not less favorable than those observed by comparable employers in the country concerned. 42. Workers employed by multinational enterprises as well as those employed by national enterprises should, without distinction whatsoever, have the right to establish and, subject only to the rules of the organization concerned, to join organizations of their own choosing without previous authorization. They should also enjoy adequate protection against acts of anti-union discrimination in respect of their employment. 43. Organizations representing multinational enterprises or the workers in their employment should enjoy adequate protection against any acts of interference by each other or each other's agents or members in their establishment, functioning or administration. 44. Where appropriate, in the local circumstances, multinational enterprises should support representative employers' organizations. 45. Governments, where they do not already do so, are urged to apply the principles of Convention No. 87, Article 5, in view of the importance, in relation to multinational enterprises, of permitting organizations representing such enterprises or the workers in their employment to affiliate with international organizations of employers and workers of their own choosing. 46. Where governments of host countries offer special incentives to attract foreign investment, these incentives should not include any limitation of the workers' freedom of association or the right to organize and bargain collectively. 47. Representatives of the workers in multinational enterprises should not be hindered from meeting for consultation and exchange of views among themselves, provided that the functioning of the operations of the enterprise and the normal procedures which govern relationships with representatives of the workers and their organizations are not thereby prejudiced. 48. Governments should not restrict the entry of representatives of employers and workers' organizations who come from other countries at the invitation of the local or national organizations concerned for the purpose of consultation on matters of mutual concern, solely on the grounds that they seek entry in that capacity. Collective bargaining. 49. Workers employed by multinational enterprises should have the right, in accordance with national law and practice, to have representative organizations of their own choosing recognized for the purpose of collective bargaining. 50. Measures appropriate to national conditions should be taken, where necessary, to encourage and promote the full development and utilization of machinery for voluntary negotiation between employers or employers' organizations and workers' organizations, with a view to the regulation of terms and conditions of employment by means of collective agreements. 51. Multinational enterprises, as well as national enterprises, should provide workers' representatives with such facilities as may be necessary to assist in the development of effective collective agreements. 52. Multinational enterprises should enable duly authorized representatives of the workers in their employment in each of the countries in which they operate to conduct negotiations with representatives of management who are authorized to take decisions on the matters under negotiation. 53. Multinational enterprises, in the context of bona fide negotiations with the workers' representatives on conditions of employment, or while workers are exercising the right to organize, should not threaten to utilize a capacity to transfer the whole or part of an operating unit from the country concerned in order to influence unfairly those negotiations or to hinder the exercise of the right to organize, nor should they transfer workers from affiliates in foreign countries with a view to undermining bona fide negotiations with the workers' representatives or the workers' exercise of their right to organize. 54. Collective agreements should include provisions for the settlement of disputes arising over their interpretation and application and for ensuring mutually respected rights and responsibilities. 55. Multinational enterprises should provide workers' representatives with information required for meaningful negotiations with the entity involved and, where this accords with local law and practices, should also provide information to enable them to obtain a true and fair view of the performance of the entity or, where appropriate, of the enterprise as a whole. 56. Governments should supply to the representatives of workers' organizations on request, where law and practice so permit, information on the industries in which the enterprise operates, which would help in laying down objective criteria in the collective bargaining process. In this context, multinational as well as national enterprises should respond constructively to requests by governments for relevant information on their operations. Consultation. 57. In multinational as well as in national enterprises, systems devised by mutual agreement between employers and workers and their representatives should provide, in accordance with national law and practice, for regular consultation on matters of mutual concern. Such consultation should not be a substitute for collective bargaining.